two of motions yesterday because this woman says her 4-year-old daughter actually spoke to a little boy who was in pajamas, dirty shoes, walking, said he was 5'15", and that he was close to their property where her father lives, and he is a registered sex offender. I am happy to bring in former federal prosecutor Neama Rahmani to talk to me about this case because there's a lot to break down. We just heard hearsay upon hearsay. Here's a mother testifying as to what her, at the time, 4-year-old daughter told her, what the 4-year-old daughter told her brother, and her brother then told her. Tell us a little about, in your experience, the use of hearsay evidence in a motions hearing like this.
Generally speaking, these rules of evidence don't apply in evidentiary hearings like this. So clearly what the defense is trying to do is suppress Joseph's confession. That's really the key evidence for the prosecution in the state. We have a missing boy presumed to be dead, and we have no real physical evidence, no blood, no DNA, aside from Joseph's confession, where he confessed to beating his son and putting him in the trunk of his vehicle. So to the extent that the defense, if they're successful in getting this confession suppressed, then the state's case is likely gone here.
So a couple of things about this that I want to ask you, Neama, and that is, first of all, we heard there were motions testimony on the first day and argument of the motions hearings that tried to get evidence suppressed, a phone that was seized 2 years after the child was reporting missing, a third statement given by the defendant 2 years after the child was missing. Now we have this testimony. If all of this were kept out, is it your opinion that this case would likely be dismissed against the defendant?
I think so. I think there's very little evidence to move forward aside from Joseph's confession. With this particular mother, I know that she's testifying as to an alternative theory of liability or cause of death, or that Joe Clyde may have been alive and walking down the side of the road. That's really a matter for trial. That's a factual issue. Something that the jury would decide. I can't imagine a judge not allowing this testimony, obviously subject to the hearsay rules. But again, without that confession, we'll see how the judge rules. I can't see the state moving forward with this case.
And how much does it impact this case? It's circumstantial. We don't have the body. We still don't know where this little boy is.
We don't. We don't have a body aside from the confession. We don't have a manner of death. We don't have, all the things that you typically have, a murder weapon, motive, means, obviously there's opportunity because, this is the father that we're talking about, and the mother who've been charged. But it's a very difficult case, absent that confession, because you have a no-body murder with no physical evidence. So this is the key evidentiary hearing in this case. Everything else is noise. The state can't get past this hurdle. They're not going to have a claim here or a case here.
And so what the judge decides is going to have a big impact on that case. After the break, we're going to do another hearing in a different trial dealing with motions. This is the trial of Megan Boswell. Megan Boswell is a mother charged with killing her 15-month-old daughter, Evelyn. We'll get you caught up in the latest developments in that story next here on Court TV Live. Neama, this case, Vinny just ended with who's responsible. Well, we know the mother's been charged now with the murder. Two questions for you. First of all, lots of inconsistent statements by the mother. So she was arrested on not murder charges, but rather giving lots of different statements. And then the second piece of evidence is that this child was found on a piece of property that belonged to a family member of the mother's. If that's all you've got, what do you think as a former federal prosecutor?
Ashley, I like this case for the prosecution. Obviously, horrific facts and incredibly sad, but I feel that they have the evidence that they need. Basically, Megan has said lie after lie after lie to local law enforcement, to federal agents, separate crime right there, and to the media about Evelyn's death. And it started with the initial lie that Evelyn was with her father, and her father is active duty military. He was stationed in Louisiana. That was the first lie. Then the second lie, that Evelyn was with Angela, the mother. Obviously, that was not true. And then ultimately, her remains are found in her father's shed or shed on the father's property. So, there's a lot of good circumstantial evidence here. I like this case for the state. And I think that Megan's completely inconsistent stories are going to be the nail in the coffin for her. And I don't think the jury is going to like her. And I agree with the state seeking life in this case.
And let's add one more set of facts to that, and that is this child had not been seen since December of 2019. So in February, that's when the grandfather reported it to the Department of Children's Services, thankfully, because an investigation revealed this child was missing. All right, in the last 20 seconds, is this a case you would expect to go to trial or rather a plea in the last 10 seconds?
I think it's going to go to trial because if you're the state, you cannot give a deal in this case. This is not the type of case where you're going to plead down to second degree or manslaughter. You got to go to first degree.
All right, thank you, Neama. I know you're going to stay with us. And after the break, we're going to look at the court. Coming up next week is the murder of Molly Tibbits. That's our next live trial you won't want to miss here on Court TV Live, your front row seat to justice. Rahmani. All right, Neama, let's talk about a couple of things that stood out to me. Anytime, if I'm on the bench and I hear that there's evidence or an argument that there were 4 individuals identified as the potential suspects, and this is the 5th individual who's now been charged with the murder, I feel like this may be good information that the law enforcement followed the evidence, which is how it's supposed to work, to find who did it and then charge that person alleging they've done it. I think that denotes, in my mind, good law enforcement work. What are your thoughts?
I agree, Ashley. And one of the defenses in these cases is always the sloppy investigation defense, that law enforcement was quick to rush to judgment, that they focused on one individual and one individual only and ignored the others. So in a case like this, where there were other folks who were interviewed and search warrants executed, that really cuts against that argument.
So now let's go to step 2, though, because that raises the next point, which is this is a case in which the defense, you just heard us saying, listen, although he confessed, it's got to be thrown out because it wasn't voluntary, because English was not his first language, but the interview where they obtained the confession was conducted in English. Good argument or not?
It's really the best argument for the defense, and that's why they pay judges like you the big bucks, Ashley, because if this confession is suppressed, the entire confession, which it was not, then you get into the fruit of the poisonous tree argument, right? And you know, all the additional evidence that was derived therefrom, including the blood in the trunk of his vehicle, and most importantly, him leading law enforcement to the cornfield, the precise spot where Molly's body was found. All of that would be suppressed. The judge didn't go that way. He only suppressed part of the confession, and most importantly, kept in the key evidence where he did admit after he was Mirandized.
I love the way you just broke that down in the fruit of the poisonous tree, because certainly, like you said, if the whole confession's thrown out, everything else obtained after that being used against the defendant is thrown out as well. But what do you think about the argument, the legal argument, that if an interview is conducted in English and that's not the first language of the person you're interviewing, that it shouldn't be considered a voluntary confession? I think it has merit, right? This is a good investigation from all appearances, but then you hear they did conduct this in English. I'm assuming knowing or realizing, or perhaps should have realized, that this person didn't have English as a first language.
It's a great argument for the defense, and their best argument, and certainly an appellate issue that we're going to see litigated, because he is not a native English speaker. He is a resident of Mexico, so Spanish is his primary language. And let's not forget, too, he was interviewed for 11 hours, so there is a decent argument on the coercion test as well. So it'll be interesting to see what the appellate courts do on the voluntariness of this particular confession.
And I agree with you. I think we're absolutely going to see an appeal, Neama. Now, what is the voluntary or coercion test that you just referenced for our viewers? What does that mean?
So for a confession or any admission to really be admissible, it has to be knowing and voluntary. And it's really a factual determination. This is where judges hold hearings outside the presence of the jury, usually before trial, and they rule on the admissibility of confessions like this. So really, the judge in this case held the evidentiary hearing, heard from law enforcement, obviously reviewed the evidence, including the recording, and decided that after the full Miranda warnings were given, Rivier's confession was knowing and voluntary. That's the test.
And this trial does start next week. We're going to cover it live here on Court TV, and it's going to be an emotional case. It's always an emotional case for the family of the victim. But you may recall in this case, the public, this family put the word out. Do you remember? I remember when it happened and all of the different publicity around, we have a missing girl. Something's not right. Here's a sign of her. Why? Molly Tibbits missing. I just remember that this was national news, that this young lady went missing, and the mother said, something's wrong, something's not right, something's happened to her. And so, we always have to keep in mind in these trials, the victim's family has to go through this trial as well. They are there, they are wanting justice, but the emotional aspect of it. As a former federal prosecutor, how much did the victim's family, their desire, their involvement come into it, if it did at all?
We've been tracking this case on Court TV for years now, and even saw an old clip of myself discussing the case. So the victim's family, particularly mom here, was really instrumental in getting law enforcement and really civilians as well to help with the search. Ultimately, law enforcement did their job. They were able to identify the right suspect and arrest him. But pretrial publicity is going to be huge in this case and an issue for voir dire and jury selection, because everyone in the state, really around the country, has heard about Molly Tibbits and knows about this case.
Yeah, Neama, I so appreciate you being on with us and you breaking it down. I know you're going to stay with us. Up next, we're going to look at a missing children's case out of California City. We'll be right back after this break on Court TV Live, your front row seat to justice. What's your gut in this case as a former prosecutor when you see this presser and this information?
Ashley, my gut is that this is a sad case. The children are probably dead, but I don't think the adoptive parents were responsible. They've cooperated with law enforcement at every step of the way, given multiple interviews. Obviously, search warrants have been executed, but they've invited them to their homes. They've even offered to give polygraph tests. I feel that this is a sad case, clearly a case of negligence, but I don't think the adoptive parents are the murderers here. I understand why the biological parents are upset. Anytime there is what we call the dependency court case here, where social services come in and they take the kids, and in the case of adoption, those parental rights are terminated, biological relatives tend to be upset, and I understand why they're upset here. But again, I don't think the adoptive parents in this particular case are the murderers.
So looking at, and I really appreciate, given I do a lot of dependency work in different capacities, the fact that once a parent's rights are terminated and the children can be adopted, then are adopted, of course, they are still going to be upset. But there's been different theories, which is, and I know that these adoptive parents said somebody must have kidnapped them, didn't see them for a few moments, the gate was open, someone must have taken them. But there's always been been a suggestion that perhaps they wandered. You see it's desert, right, in the back and close to the home. There's a lot of land, that they wandered away and then something happened to them, be it animals or, something out on the land. What is the reality of that and your experience, based on the fact that clearly law enforcement is investigating, but they have not found any evidence of either of these two toddlers?
Yeah, it's certainly possible that they wandered and passed away. They were so young, 3 and 4 years old. This is a rural part of California outside of Bakersfield in Kern County. Mom was inside, dad was chopping firewood. So it's obviously possible that they weren't kidnapped. They just wandered off. But again, they're so small, they can't really wander far. And there's been such an extensive search, we would expect to see some evidence, some blood, something, even if they were attacked by wild animals. So anything's possible, but that's not, in my humble opinion, the most likely result in this particular case.
And I understand the frustration of the community and the people that we've heard speak out about this, because the other thing I think is, okay, let's say somebody did kidnap them and either drove up in a car or some type of vehicle. They couldn't have just walked up and walked off. You think they'd be seen if that had happened. That why wouldn't have the adoptive parents have heard a car, the children wouldn't just freely go, presumably, with someone and not make a noise. They might scream, they might laugh, they might cry. Who knows what they do? And so I think there's also this feeling of it doesn't make sense, right? None of this makes sense. Two toddlers don't just disappear, never to be seen or heard from again. And that part I think is very hard for people to understand.
I agree, and I think that's why folks in the community are frustrated. It's been 4 months. There's little to no evidence. There's really no leads. Law enforcement has essentially said that, at least at this time, the adoptive parents aren't a suspect, but they have really no theory of culpability, who may be responsible, what may have happened to these poor young children. And all we're hearing is, family members, members of the community who are upset at these adoptive parents who actually have other children that they've adopted as well. So these aren't the only two. And I completely understand their frustration because we really don't have any good leads at this point.
Yeah, completely agree with you. I know you're going to stay with us. Up next, we're going to take a look at the press conference the adoptive parents in this case had and a body language expert who gives her thoughts on this case. Stay tuned here on Court TV, your front row seat to justice. Prosecutor Neama Rahmani. Neama, yes, they've cooperated. They have given all of the evidence. They've allowed them to take their phone, their cars. They've done what they've been told. Is it possible, though, that perhaps they did all that because they know where the children are and they know nothing in their possession is going to incriminate them? Just playing devil's advocate.
Sure, Ashley, anything's possible, but their demeanor, their conduct, their statements, they've all been consistent with someone who is innocent. They've done everything that you would expect from parents who lost their child. Again, they're not mistake free. It's just not a criminal matter, in my opinion, at least not yet. They immediately searched for the children. They reported them missing, right, within minutes or certainly within an hour, not months like some of the other cases that we've been talking about today. They've, voluntarily, even though there were search warrants, they've consented to searches. They've consented to turning over their technology. And despite all of this, law enforcement hasn't been able to find one piece of evidence, at least nothing that they've discussed publicly, that ties these two to their disappearance or any other criminal act.
Let's listen. There was the human behavior expert, Susan Constantine, who listened to and watched and then gave her opinion. And I'd like to listen to that now about heavy breathing.
Right out of the gate, you notice that he takes this deep breath, right? So usually when somebody takes a deep breath, it's like something horrible. I'm going to tell you something very emotional. But what you don't see is that it trickles off slowly. There was a couple deep breaths in and out. His wife mirrors it, and then also all of a sudden it just dissipates. Real emotion trickles off. It doesn't just abruptly stop. The other thing, as I noticed, is that he speaks in what we call sound bites, and I know we know that in television too. But he has bullet pointed conversations. So I went in the house, I went outside, I know the door is open, and there's these very bullet point. What he's doing here is he's not elaborating. He's assuming the person that is listening is filling in the blanks. So the way he is thinking, cognitively, the way he is thinking is that he's trying to not reveal too much information, let us kind of fill in the blanks. The fact that he's not filling in the blanks and that it's not fluid language creates pause for me, because this is also what we see in deceptive behavior.
So that didn't trickle off, and the bullet pointed conversation by the adoptive father until Susan Constantine, the behavioral expert, pointed it out.
Well, look, obviously I'm not a behavioral expert, but I can tell you, and as you know, that testimony, those types of experts will never be permitted in any court. Any jury can evaluate the truthfulness or lack thereof of a witness or a criminal defendant. What I see is something different. Non-expert opinion, here's someone who's being truthful, here's someone who's being honest, here's someone who lost his children. And let's not forget, it's hard to adopt children, at least here in California. It's certainly much harder than having a biological child. So these are two parents that really have to go through the process, the dependency court process, to adopt these children. These are two children that they certainly wanted, and it's Sounds, at least to me, my perception is that they love their children and they're devastated that they're missing.
I want to see if we can bring a picture back up of the two toddlers. They're beautiful children. And when you look at them and see them and think you're right, they've been through all this process, they've been through some trauma, and here they are. Thank you for bringing those up. Here they are in an adoptive home now who said we picked their names. Here they are. Beautiful, beautiful little boys. It again doesn't make sense. So I do want to continue to listen to the breaking down. The next thing that Susan Constantine, or rather another thing that she looked at, was the parenting that she observed. Let's see what she had to say.
So what they're doing here is parroting one another. When one says something, then the other one kind of hitchhikes and parrots the same.
Pointed out during their press conference that the adoptive parents chose to speak out publicly. It sounds pretty reasonable that there are different things indicating deceptiveness. So you still don't buy in? You still think that they appear to be honest and truthful?
It's possible, obviously, that they're involved in the disappearance and they're lying. No question. I'm not going to eliminate that. But, to say that someone is guilty because they're too polite, that seems like a stretch in my opinion. And again, I think it's time for law enforcement to shift their attention to some other theories. I think this is a dead end. I'm not saying that you're going to rule them out as suspects. You don't necessarily have to do that, but you've really done everything you can with respect to these two in terms of search warrants. You've dug up the property, you brought your cadaver dogs. There's really no evidence linking them to this murder or this disappearance aside from really being negligent. So I want law enforcement to expand their search a little bit. Maybe they can find the answers if they stop focusing on this mom and dad.
One of the things I really appreciate is the passion of the community, the interest of the community, and law enforcement. Every time I see an interview with them or a statement that they've made, they are committed to this case and these two children. Give me some perspective on, because we don't always see that, but in this case, it certainly seems to be true.
Yeah, credit to local law enforcement there and the FBI. Sometimes in, these larger cities, I'm sitting here in Los Angeles. I know you're out in Atlanta. You don't get that type of, personalized attention from law enforcement. Just the jurisdictions are too big. But this is a small city, out there in rural California. And I love what law enforcement has done. And I really appreciate how the community has come together. Everyone has helped search for these children. And I hope it's just a matter of time before we get something that breaks this case open.
Absolutely. We're going to continue to cover that, and prayerful that these little boys are found and found safe. Court TV provides nationwide coverage, so we're going to move from California to Idaho, where after the break, we're going to look at a story from Idaho about a grandmother who is charged with the killing of her 9-year-old granddaughter. Stay tuned. We'll be right back here on Court TV, your front row seat to justice.
Native women have told me that what you do when you raise a daughter is you prepare.
Federal Prosecutor Neama Rahmani. Neama, I got caught up in my words because the community just expressed, look, we're happy there's arrest. This is a start. This is a place to start for some justice. What do you think of the arrest and then the additional charge of the voter fraud?
Yeah, this arrest is interesting because we've been tracking this case for about a year now. She disappeared in this really rural part of Colorado. I know Suzanne's brother has gone on national media like Dr. Phil and thought that Barry was responsible, but we don't really have a lot of evidence as to what the state has against him. The probable cause affidavit is sealed. The prosecutor who was handling the case, when she, made her press conference, she didn't provide any information. She just said that she's very confident in her case and that she doesn't plan on offering any deals. So I expect that it's a very strong case because of how aggressively they've pursued it, but we are really at a loss as to sort of commenting on the evidence that the state actually has. With respect to the voter fraud, that's a layup. That's a very easy case. He's obviously voted for her, and that's going to be a separate federal offense. We'll see how aggressively the feds actually pursue it.
Thank you. I didn't mean to interrupt you. I would love to know your thoughts on when a public official, such as the prosecutor in this case, makes an announcement that says, I'm confident in the evidence, and that's it. There's no more. There's no indication. Do you think there's any obligation to reveal more than that? Because I know people want to feel like, okay, there really is some good evidence supporting this charge.
Actually, I'm a big believer in transparency in our criminal justice system. So, when prosecutors do that, I understand they're elected officials and there's a lot of political pressure on them to pursue a missing mother case, but they really owe it to the public. And same thing with law enforcement to at least discuss some of this evidence. There's no reason to keep an affidavit sealed like this unless the investigation is still ongoing and it might compromise the integrity of the investigation. But unless there are other folks involved here, we don't expect to see any additional charges. So really, these documents should be unsealed. The public and the media, like Court TV, should have access to them because, again, these trials are public. This is all public information, and there's no real good reason to keep it confidential.
Right. And there's no body, right? And so it's not as if there's been information or publicity about this is what happened and we know where she is and you have that information. Nobody even knows that. I mean, there isn't a body, so we don't know what happened to her really at this point.
We don't. There was speculation that, there might have been wild animals involved. We've talked about that in, the case involving the young children. I mean, this is something that was certainly possible given the very remote area where she disappeared. But, I know that Barry had an alibi. He was, out of town when allegedly she disappeared, but he made some sort of strange statements, when he was first contacted about his missing wife. He said, well, have you checked her bike? So I know there's some evidence. Actually, I just don't know exactly what it is, but they got to have something good if they came out this aggressively against Barry, both law enforcement and the prosecutors. So I'm hoping to hear something relatively soon from them.
Right, absolutely. What do you think of no bond and the fact that we know there's no bond, but don't, again, know any details about exactly what the evidence is? I'm assuming at the bond hearing that the court heard enough to say no bond.
Yeah, I agree with no bond in these murder cases because you're looking at risk of flight and danger to the community. Certainly someone who's a murderer and can allegedly kill his wife, that person is a danger to the community. And obviously risk of flight as well. Colorado is not a death penalty state, but he's still looking at potential life for a first-degree charge, and flight is always a consideration when you're looking at a sentence as long as life or even 25 and above. So I do believe no bond is appropriate in these cases.
And what, from your perspective, is a speedy trial? So we all know that defendants have the right to a speedy trial. What does that mean? Does it depend on how quickly cases get to trial in a particular jurisdiction?
I know it's a big issue right now with COVID because prosecutors are having a tough time getting jurors, depending on the state. You need sometimes 12 plus alternates to sit together in a room and deliberate. It's challenging. Obviously, courts are opening up now, but it's been a big problem over the past year or so where folks have sat in custody because they're unable to bond out, but they're also not afforded their right to a speedy trial. So we're looking at a significant number of speedy trial motions from criminal defendants all across the country.
Yeah, I absolutely agree with you. And there's a big backlog in lots of courts because of the pandemic and closings. I want to listen now. Suzanne's brother, Andy, spoke last September. There was an interview from during the search time. I'd like to listen to that.
I've known Barry since he was 19, I guess, maybe a little before. And he's always been a hard-working guy. Good brother-in-law. I guess we weren't all that close, but only because we're busy. Other than that, heck of a baseball player. Well liked. I would love it if Barry got eliminated out of this. That would make me feel great. That in itself would be success. Of course, I want to find my sister and bring closure to my family, but I certainly don't want this to be Barry.
Often I feel like in these cases when relatives are interviewed, they often say, I'm not surprised. Yeah, I think they did it. And anger, frustration. But in this case, that's not what he had all said. And that's the victim's brother. And we don't know where she is. We don't know exactly what happened to her. But he was, likable guy, Barry is.
Well, he's also given some other statements, though, that he said that he did suspect his brother-in-law in the disappearance. So, Andy's given different statements over time to different media organizations. I know Suzanne's family has been very present in the media discussing their sister's disappearance because really, just like us, they had no answers. We were at a loss for almost a full year until really this breaking news of an arrest came out just a week or two ago. shortly before Mother's Day. So I know he gave that one statement, but he's given other ones where he does say that he believes that Barry may have been involved in Suzanne's disappearance.
And prosecutors' offices should have, theoretically, all of them. Hopefully, funding may be an issue, but victims' rights advocates. And they are there to work with the victim's family and work them through the process and understand and make it less traumatic for them as much as that's possible with these horrible cases. But in this case, it does sound still like, even though that might be happening, the family of the victim of Suzanne don't know any more than the rest of us. And so I do wonder about your take on the transparency part. Of course, you can't interfere with the investigation, the charges, or the trial, but does the victim's family have a right to know more information?
No question, Ashley. I know there's some adult children as well, young adult children that deserve to know answers. I mean, they're victims. Their mother has disappeared, seemingly murdered. Now their dad is in custody, maybe serving a life or close to life sentence for that murder. So they deserve answers because both of their parents are affected as they are as well.
Neema, I really enjoy talking to you. You make great legal points and also the reality of situations. You're going to stay with me, and after the break, we're going to take a look at the motions hearings that were held this week in the killing of Ahmad Arbery. Stay tuned. We'll be right back on the other side. I must ask you about first the prior acts. So, what about this argument that the prior acts of the defendant should be allowed in, noting that these prior acts are from years before? They're not close in time to this incident, but rather during his past. Do you think those are admissible?
The prior acts of the defendant, or the prior acts of Ahmad Arbery?
Of the victim, I'm sorry. Of Ahmad Arbery, of the victim.
So actually, I don't think those prior acts are going to come in. I understand why the defense raised this motion. It's a creative argument. I give them an A for effort, but it's not going to come in for several reasons. They're only potentially relevant to the issues in this case, which are Georgia's now repealed, but they used to have a citizen's arrest law, and the self-defense argument. And we know the McMichaels are going to argue self-defense. So the question is, did they know about Ahmad Arbery's past, number one, when they tried to execute that citizen's arrest? And really, admittedly, from their own attorneys, the answer is no. So I don't think the prior run-ins with law enforcement will come in because there's no evidence whatsoever that the McMichaels had knowledge of that. Then the second issue is Ahmad Arbery's sort of relationship with law enforcement and how he reacts to being confronted. Again, I don't think that comes in either. And the reason is this: generally speaking, unless in a self-defense case, a victim takes the stand and he or she testifies that he is peaceful, then that testimony may come in, that evidence may come in to impeach the testimony that the victim is peaceful. But in this case, the victim is deceased. So generally, it's not going to be relevant. I don't expect the judge to allow it in. It's really an effort to dirty up Ahmad Arbery, and it'll open the door to all sorts of collateral issues and witnesses testifying in unrelated cases. So I understand why the defense wants to bring it in. It's great for them to make Ahmad Arbery look bad in front of the jury, but I don't expect the judge to allow it.
And I appreciate that the judge took a lot of these things under advisement. He had conversations about the law and what it says. He's allowing both sides to submit some briefs and responses on particular issues around, for instance, the relevance of the mental health. I want to move to that now, the mental health piece, because the defense is saying that the mental health illness that plagued, and this was their words in the motion hearings, that plagued the victim in this case, plagued him for the 8 years before the incident that left him dead, are admissible. What are your thoughts about that and evidence of his mental health illness?
I don't think it's going to be admissible, Ashley. We're opening the door. Imagine every time a victim of domestic violence, sexual assault, in this case, obviously there's an allegation that there's self-defense involving a firearm. Imagine if their mental health becomes an issue every single time. I mean, you're dealing with all sorts of HIPAA issues, privacy issues. Are you going to allow criminal defendants to subpoena mental health records, other medical records? It's just opening the door. Again, I don't think any judge will allow it. I understand why the defense wants it, but it's really going too far, and any remote probative value is going to be outweighed by the prejudicial effect to the victims of crime.
And the judge certainly expressed during the motion hearings his sensitivity to the fact that it is a person's medical record, mental health information, and he will be cautious, and that is not something he's just going to say, come into evidence and it gets released everywhere. I'd like to take a minute now to listen to Attorney Sheffield and what he had to say about the mental health of the victim in this case.
What we're talking about is that we have...
The third thing I want to talk to you about, and to me, evidence-wise, it's fairly straightforward, but I might be wrong, so push back on me. Inmate calls. The defense argues certain of those calls are not admissible, that the defendants had a right to privacy. What about inmate calls? They know it's being recorded, and generally in trials, they're allowed in because you waive that right to privacy when you make a call and you know it's being recorded and you are incarcerated.
Ashley, I agree with you 100%. No good argument on the other side. These calls are not confidential. They're admissible in every single case. Defense is grasping at straws and making arguments that really have no merit. Those jail calls do come in. They always come in.
All right, let's listen, though, to some of the sound about how many calls there were.
We talked Monday over at your office, and there was some mention of your being in the process of downloading about 1,500 phone calls. Do you remember that?
That was not me, that's the undersheriff.
But you were there when he mentioned that?
I was.
Are you involved in that process of downloading those phone calls?
Those particular calls, no, I'm not.
Are those 1,500 calls in response to these several letters we just went through, or is there another request someone's made?
I have not seen the request, I'm not sure.
So no requests in writings come to you?
Not to me.
Do you have any firsthand knowledge of whether those 1,500 phone calls are all phone calls of all three of these defendants during their entire time they've been in the Glenn County Jail up to now?
I have not seen the request.
Okay. So your answer is you don't know what those 1,500 phone calls are?
No, sir.
Or who requested them?
I'm not sure.
All right. That's all I have, Your Honor.
So, Neama, would you go so far as to say that all 1,500, regardless of who the defendants were speaking to respectively, are admissible because they were recorded while they were incarcerated in jail?
Well, to the extent that they're admissions of the criminal defendant, they are admissible. But I think the issue is the prosecution. You want to err on the side of caution. You just want to dump everything on the defense. That way there's no allegation of discovery misconduct. You're withholding something that may be potentially impeachment evidence or exculpatory. But we know there's a lot of evidence in this case because we know in the federal case, the federal prosecutors have disclosed that there's more than 1 terabyte of data discovery that they have to produce to the defense. And that's well over 1,000 file cabinets, I believe, of paper documents if they were actually printed. So there's a lot of evidence in this case. Both the state and local law enforcement, as well as federal agents, have conducted a very extensive investigation here. So there's going to be a lot of evidence here. A lot of witnesses were interviewed, a lot more than these jail calls.
And, you know, live trial coverage gives individuals the benefit of also seeing and understanding how much attorneys have to do to even prepare to go to trial. Up next, we are going to look at our trial that starts next week. Jury selection begins Monday, and the trial of the murder of Molly Tibbits. We'll talk about that here on Court TV Live. Neama, this kind of case horrifies me because no murder case is good, but typically it's by someone that is known to the victim. This is a case in which the accused has no relationship whatsoever to Molly Tibbits.
Yeah, actually, it's terrifying. You know, reportedly he's stalking her, and when she threatens to call the police, which is her absolute right, he loses it and stabs her. So I understand why everyone is just completely distraught because it's such a heinous, horrific crime here.
Yeah, it absolutely is. So there we see him, and he is the defendant in this case. We know that English is not his first language. At least that's the allegation made in terms of his confession not being valid because it was not voluntary, because the interview was done in English. Does that hold weight in your mind?
It's really the only argument here. That's why I don't expect any type of plea that would involve an appellate waiver, whether it's with a plea agreement or an open plea before the court, because Rivera here, he really has to preserve that issue. I know the judge has already ruled against him, but it has to go up on appeal. That's why I expect this case to go to trial, because even if there's a weak case from a substantive perspective, if they're successful on appeal, the primary evidence in this case, we talked about the fruit of the poisonous tree, it's all going to be suppressed, and he has a great chance at an acquittal then, or even an outright dismissal.
And you went right to what I was thinking about, which is why not have a plea in this case? So for viewers, and if a defendant chooses to enter a plea, do they necessarily waive all their rights to appeal in entering that plea?
Generally, yes, Ashley, but I have, in the thousands of cases I've prosecuted, I have occasionally, if there's a novel appellate issue, and that's really the only issue in the case, to preserve judicial resources and government resources, and as well as the judge and the jury's time, I have done plea agreements that have that carve out that appellate issue that allows the defendant to appeal. But that's really the only issue. But most of the time, these plea agreements and pleas before the court, they have an ironclad appellate waiver. Defendants can't plead and still preserve issues for appeal.
And just knowing what you do, what do you expect in terms of the case next week and what type of trial we might anticipate in the last 30 seconds?
I anticipate a relatively quick trial with the state putting forth evidence. Not much of a defense here, really. You'd expect defense counsel just cross-examine the government witnesses, maybe point to those 4 or 5 other alleged individuals. But again, very tough to defend this case when he took law enforcement to where her body was and he made a full confession.
Is it going to slow the case down knowing that he may need to have an interpreter given English is not his first language?
Yes, those interpreter cases always proceed slowly because you have to have that court-certified interpreter there interpreting everything for the defendant.
Right. Neama Rahmani, I've so enjoyed having you. Thank you for joining Court TV to continue to break down all of these cases. We cover cases nationwide, coast to coast. Next week, Molly Tibbits, as well as the Durst trial, and we'll see. We're going to see what happens with the motion that's been made in that. Up next, Michael Ayala will be in the anchor seat. He will get you caught up on all the latest and our next big trials on Court TV. You don't want to miss it. Stay tuned. Happy to be with you this afternoon on Court TV Live, your front row seat to justice.